All rise.
The Kosovo Specialist Chambers is now in session.
Welcome, please be seated. Good morning and welcome to today's hearing. Court officer, can you please call the case?
Good morning, Your Honors. This is case KSC BC 2020-04, the Specialist Prosecutor versus Peter Shala.
Thank you. First of all, I kindly ask you to indicate who's present for today's hearing, starting with the Specialist Prosecutor's Office.
Good morning, Your Honors, and good morning to everyone else. Today, for the SPO, we have the Specialist Prosecutor, Kimberly West, our case manager, Line Pedersen, our legal interns, Guozhen Zhao and Ella Patzenberg, and then in the first row, we have Gaia Pergolo, Eva Wieler, and myself, Filippo De Minicis.
Thank you. Victims' Counsel, you have the floor.
Good morning, Your Honours. I'm Simon Laws, counsel for the victims in this case, together with my co-counsel, Maria Radziowska.
Thank you. Defense, please, your turn.
Thank you very much. Good morning, Your Honours. So we are here with Mr. Peter Shala, as usual, from video link from the detention center. We are here with my two co-counsel, Mr. Elia Winnie and Ms. Leto Kaliorou, the case manager, Ms. Zaneta Petrovica, an assistant legal officer, Ms. Kaylin Chin, and two assistant legal officers, Junior Kolb, one legal assistant officer, Judith Kolb, and a legal assistant, Alana Gonzalez, including Mr. Basil Moreira, a legal intern. Thank you very much.
Thank you, counsel. Mr. Shala, can you confirm that you hear me well?
Good morning, everybody. I can hear you very well.
With the closing statements, we will follow the agenda as set out in the panel's decision on the closing statements and related matters, which is filing 824. We will start with the closing statements of the Specialist Prosecutor's Office. This hearing will be held in open session unless otherwise requested by the parties or the Victims' Counsel or decided by the panel. Mindful of the principle of publicity, I repeat our directions that parties and Victims' Counsel that they should present their closing statements as much as possible in public. Yeah? However, in order to ensure the protection of the victims and witnesses, parts of this hearing will have to be conducted in a private or closed session. And to this end, I remind you to give me prior notice should, for the purposes of your submissions, you would need a private or closed session. Yes? Very well. I also, and it's an important point, I also remind you to inform me and the registry that if there are visual aids which cannot be broadcasted to the public. And also to indicate to us when a document should not be broadcasted anymore. The reason is because it has repercussions for what can be shown to the public if we are broadcasting documents. So that's an important point because then there can be no broadcasting of the courtroom. Not least, I remind also the parties and Victims' Counsel to adhere to the in-court procedure for requesting redactions. We have been doing that throughout the trial. And before we proceed with the closing statements of the Specialist Prosecutor, we want to address 2 points with regard to the defense. First, the panel notes that the defense filed its trial brief, which is filing 821, on the 26th of March. we note of this year, we note that it is 1 day after the deadline set by the panel. This was due to technical difficulties, as explained by the defense, and given its importance of the final trial brief, and because of good cause, we recognize this set filing as valid pursuant to Rule 9(5)(b) of the rules. So that is set. Another point is that we noted that in the final trial brief, the defense reserves its right to make additional submissions on sentencing after conviction, if any, of course. And this is filing 821, paragraph 308. And the panel draws the attention of the defense to our oral order of the 25th of October. And I refer you to the transcript of that same date. And to be more concrete, that is page 3153, line 9, to page 3156, line 24, according to which it has already decided that in case of a conviction, it shall determine the appropriate sentence with the pronouncement of the trial judgment in accordance with Rule 159 of the rules. And I trust that this is clear to you and that any submissions of this nature should be made this week at the indicated time. And I see you nodding, Defense Counsel. Thank you. This concludes the panel's remarks. We can now begin with the closing statements of the SPO. You have been allocated 5.5 hours. Please inform us if there are any changes time-wise. And then for now, you have the floor.
Your Honors, when the accused left Albania for a life in Belgium in 1999, perhaps he thought that he could walk away from his crimes, from his victims, and leave it all behind him. But there is no statute of limitation on war crimes. Those who have committed war crimes, Your Honors, do not evade responsibility, ever. They can be prosecuted wherever they are and whenever they are found. It is thanks to this principle that we could bring the accused before Your Honors today to face trial. We're now asking Your Honors to find him guilty for the crimes he committed. This is the second war crimes case tried before this court, the second one that comes to a close. And it is a case about accountability. The victims of the accused crimes, Your Honors, they could not walk away. One of them died at the Cookers Metal Factory. The others carry permanent physical scars and remain haunted by that experience. For them, there was no forgetting. They and their families have described to this court the deep and enduring trauma they suffered. Most of the witnesses were not telling their story for the first time. They had done so over many years, including in prior trials. But they were willing to do it again, to relive those events, because they still believe in the possibility of justice that this court can offer. They believe in the principle of accountability that has brought the accused before this court. The charges in this case concern crimes committed between approximately 17 May and 5 June 1999 in an old metalworks factory in the town of Kukës, in the northern part of Albania. With only a few exceptions, the victims were Kosovar Albanians. Pieter Shala, the accused in this case, is charged with the war crimes of arbitrary detention, cruel treatment, torture, and murder. During the indictment period, he was a member of the Kosovo Liberation Army. The victims in this case, both women and men, were targeted by the accused and certain other members of the Kosovo Liberation Army on vague and unproven accusations of being traitors or spies. They were apprehended when they were at their most vulnerable. They were kidnapped on the street after fleeing their homes. They were picked up from refugee camps where they had found shelter in Albania, or arrested as they were trying to join the Kosovo Liberation Army. They were deprived of their freedom and arbitrarily detained at the Kukës metal factory, where they were kept in inhumane conditions and mistreated by the accused and other perpetrators. They were made to live in fear for days and weeks. Their detention, Your Honors, was entirely illegal under international humanitarian law. The violence used against them, however, was not only criminal, but it was against any form of human decency. One of these victims was a young Kosovar Albanian who was arrested, severely beaten for days, and then murdered. He posed no danger at all to the perpetrators, who nevertheless decided to take his life. The accused was one of these perpetrators. The murder victim, Your Honors, did not live to see the end of the war. He could not celebrate it with his family, his friends, and his loved ones. Nor could he see what awaited his country, Kosovo, after the war. The accused and the other perpetrators took this opportunity away from him. They denied him the right to live his life, to work, to travel, to love, maybe have children, and to grow old. He could not stand here before Your Honors to tell you what they did to him, how frightening that was, and how much it hurt. The other victims, those who survived, bore the physical and psychological consequences of their mistreatment for years after that experience. Some of them still do. Memories of their detention in Kukës haunt them in their sleep, as well as when they are awake. 25 years after the facts, in this case, Your Honors, these memories still affect their ability to live normal lives, to hold a job, or to simply have trust in other people. The prosecution case is that the accused took part in these crimes in concert with others, but also individually, with the required intent. His participation was continued, significant, and extremely violent. Your Honors will hear more about it in the course of our presentation. The prosecution case rests on multiple and solid pillars. The evidence on the accused's responsibility comes from different witnesses whose evidence is consistent and mutually corroborating. In addition to their evidence, Your Honors, we have the statements of the accused himself. He admitted that he was in caucus during the indictment period. He admitted taking part in some of the crimes, although his admissions in that regard were only partial. Then we have the evidence of KLA members who were at the factory and saw the accused there at the same time that the victim said he took part in their mistreatment. Your Honors, it all fits, it all shows that he did it. Not all the victims, unfortunately, had the opportunity to testify here. Some sadly have died before this trial. But their stories survive in their prior statements, in the accounts of their fellow detainees, and in the testimony of their family members. Indeed, their suffering is reflected in the partial admissions of the accused. Therefore, Your Honors, and we want to make it clear, as we've made it clear in our trial brief, we're not asking this court to find the accused guilty solely or to any decisive extent on evidence the accused could not confront at this trial. The court has heard from multiple mutually corroborated witnesses, which together with other evidence prove the prosecution case beyond reasonable doubt. Your Honors, how does the defense respond to the charges and to the evidence presented in support of these charges? The defense case is that the accused was a freedom fighter. He left Belgium in 1999 to go to Albania to fight for the freedom of his country. He was only occasionally at the Kukas metal factory where he went to take provisions, but then left back for the front lines. The accused, the defense claims, had nothing to do with the crimes he's charged with. The defense case is that the witnesses who identified the accused as one of the perpetrators are either lying, wrong, or both. All of them. It doesn't matter that the accused himself admitted that he did, in fact, beat some of these victims, that he said he doesn't regret it, and that he would do it again. Defense witnesses, Your Honors, claim that they never saw Peter Shala at the Kukas metal factory, or even that they did not even know who he was. But these, Your Honors, are the same witnesses who never saw the detention building in the middle of the Kukas metal factory. A building they passed in front of for months during their service with the KLA. Impossible to overlook, as you will hear and see from the presentation of my colleagues that will follow mine. They never saw this building, as they never saw the accused. The evidence before Your Honors shows that these witnesses were not telling the truth. The victims, however, they didn't lie. Their stories match and are corroborated by the statements of the accused. The sentence requested by the SPO is the result of careful consideration of all the relevant factors, but especially the conduct of the accused, of his own actions, and of the consequences they caused. His contribution to the crimes, Your Honors, was significant. He displayed a sickening degree of violence against his terrified victims. And, Your Honors, beating people who can't defend themselves is not fighting. It's an unjustifiable and cowardly act of violence. The accused did nothing to alleviate their suffering. He could have at the very least walked away from their carnage, but he didn't. He beat them one after the other. And time, Your Honors, hasn't changed his propensity to violence. It's for all these reasons that he deserves severe punishment. Ms. Wheeler to my left will now show you and the public the locations within the Cookes Metal Factory where the accused and the other perpetrators committed these crimes. She will show you how the treatment of the victims amounted to the crimes of arbitrary detention, cruel treatment, and torture. Ms. Pergolo will then discuss the incidents set out in sections 5E and 5F of the prosecution brief. She will show you that murder was committed. She will address witness credibility and respond to specific defense allegations on that matter. I will then take the floor again to illustrate the timeline of the accused's involvement in the charged crimes, discuss his criminal liability under the applicable law, and finally, Your Honor, in the end, I will respond to certain defense allegations with regard to the credibility of trial witness 1. I will do that in the end because part of that, a large part, will need to be done in private session. So rather than interrupting the publicity of my presentation, I prefer to do that in the end so that we can lump in the private section in one part.
Very good.
Ms. Wheeler will now take the floor.
Good morning, Your Honors and colleagues. In the next approximately 30 minutes, I will take us and the public to the place where the ordeals of the victims of this case happened. And I will guide you through the premises of the Cookes Metal Factory, which in 1999 became the crime site of arbitrary detention, cruel treatment, torture, and murder. The detailed accounts of those who survived their mistreatment and torture at the Cookes Metal Factory are provided in the SPO's final trial brief. Before Your Honors and the public today, I will present a brief outline of what happened in 1999 at the Cookes Metal Factory and what the evidence establishes in regard to the 4 counts charged in the SPO's indictment. Throughout this trial, Your Honors have heard the account of witnesses and victims who courageously came forward to testify, describing how they, or persons dear to them, were taken to the Cookes Metal Factory and detained there in inhumane conditions. They described repeated abuse, most brutal beatings. Their stories are coherent, they are consistent, and they are amply corroborated by each other. Their evidence establishes all of the elements of the crimes charged in the indictment and the responsibility of the accused Peter Shala for those crimes. The crimes charged in this case all took place in Cookes, a town in Albania, located approximately 20 kilometers from the Kosovo border, in their local KLA headquarters, now marked with a red dot. The KLA headquarters was set in the premises of an old metalworks factory. Located at the road going to Krume, now marked in red, the Cookes Metal Factory had an entry gate, now marked with a red arrow. The KLA used these premises as a mobilization and logistics center for military operations conducted, among others, between the border of Kosovo and Albania. However, as set out in the SPO's final trial brief, some KLA members, which included the accused, also used these premises for the commission of crimes against at least 18 victims. None of these victims was taking part in the hostilities at the time of their arrest, of their detention, or mistreatment, or for one of the detainees, when he was killed. None of them posed any military threat to the KLA. In any event, once they were in the custody of their captors, they were all entitled to the protections afforded to them by Common Article 3 of the Geneva Conventions. The victims were arrested, abducted, and taken to the Cook's metal factory, where they were detained, some of them for a few days, some of them for over a month. No reasons for their arrest were provided, besides some generic and unsubstantiated allegations that they were traitors, collaborators, or spies. While they were repeatedly and harshly interrogated, they were never brought before a judge or other competent authority, or otherwise given the possibility to challenge their detention. No basic procedural guarantees were afforded to them, and I refer to paragraphs 328 to 337 of the SPO's final trial brief for further details. This made their detention arbitrary and thus illegal. At the Cook's metal factory, the crimes charged in the indictment principally took place in two locations. The building referred to as the command building, now visible on the lower left, on the lower right of the picture, and the detention building, now circled in red in the upper center of this aerial photograph. In these two buildings, the victims of this case endured a horror beyond words. Let us have a closer look at these locations with the help of the SPO's 3D model of the premises of the Cook's metal factory. To get to the command building, we entered the Cook's metal factory through its main gate. It is the same entry gate the victims passed through when they were brought to the Cook's metal factory. Once there, the command building was on their left-hand side. It is a two-story building, now visible on the picture shown on the right lower corner, where KLA officers and soldiers slept and had office space, and where they detained and mistreated their detainees. The accused has described this building as the very heart of the headquarters. The door to the command building, now marked in red and enlarged on this picture, led into a small entrance area. Opposite the door, across this entrance area, there was a staircase leading up to the first floor. You can now see the view down on the staircase from this first floor. The wall you can see on the left-hand side of this picture is the wall the staircase shared with the detention room in the command building, which we can see here. This was the room where witness 1448 was taken to when he was brought to the Cook's metal factory on or around 18th May 1999. 1448, a Kosovo Albanian and immigrant worker in Germany, had traveled to Albania to visit his family, but was arrested by KLA soldiers before he could reach them. On this sketch of the command building 1448 made, now visible on the screen, he marked this room as the prison in the attic. Witness 4733 and the murder victim, both fellow Kosovo Albanians, eventually joined 1448 in this room on or around 20 May 1999. They were detained in this dark, narrow space with no windows no insulation, with some dirty blankets and bottles filled with urine. The slanting roof did not allow the detainees to stand upright. One late evening, it was around the 20th of May 1999, 4733 was taken out of this room. He was taken down the stairs, through the ground floor corridor to an office room, to a night of most brutal beatings. Trial witness 1, who was taken to the same room that very night, he marked this office room on a picture shown to him during his testimony before your honors. And he marked it with a blue dot now visible on your screen. He identified it on the ground floor as the third office. 1448, taken again to the very same room that very night, also indicated the location of this office on the sketch he made of the command building. And he also marked the third room on the ground floor, calling it the beating room. The inside of this very room can be seen on a video shot by defense witness 3887 on or around 2nd of June 1999. 3887 identified the room where he made that video on a picture shown to him of the command building during his testimony before your honors. And he marked it as a number 2. Clearly the same location as indicated by the victims. For comparison, you can see trial witness 1's marking on the right down corner. The video of which I'm going to show you a short sequence of shows a gathering of approximately 10 KLA soldiers. It shows the interior of that room. We can see a bunk bed, we can see a piece of furniture in the corner, a table in the middle of the room, and chairs or benches to sit on. When 4733 was brought to that room on or about 20 May 1999, he described a gathering similar to what we just saw in the video, but of different KLA soldiers. The group that night included, among others, the accused, Sabik Getzi, and Shemshir Krasniqi. 4733 recalled in his previous statements, for example, in his 2002 ICTY witness statement on page 2, that when he entered the room, the KLA soldiers were drinking. They sarcastically welcomed him to a party in his honor and set him down to what unfolded as a night of most brutal beatings. That night, 4733, trial witness 1, 1448, the murder victim and further detainees were subjected to most brutal violence. Most of the victims of that night were fellow Kosovo Albanians, accused of having ties with Serb institutions, being collaborators or spies. They were beaten with whatever the KLA soldiers present could get a hold on. Baseball bats, metal bars, rubber batons, and guns. Their tormentors hit the victims as hard they could, all over their bodies, until they lost consciousness. One victim vividly remembers that the accused was smiling as he hit the first blow against him. And 4733 stated that the accused hit him like a horse. When the victims fainted, the perpetrators threw water at them to make them regain consciousness, just to continue their mistreatment. They were covered in blood. The beatings inflicted on them caused them unbelievable pain. And yet, to make them suffer even more, their tormentors threw salt in their eyes and wounds. In addition to the beatings, 4733 was repeatedly burned with cigarettes, and they pushed a baton in his mouth, breaking his teeth. With another victim, the perpetrators placed a plastic bag over his head, tied it around his neck, and they poured water over his head. In all this misery, the victims were deliberately made to witness each other's mistreatment. 1448 was made to watch the torture of 4733, and he remembered that it looked as if all of them were in some sort of competition to beat and humiliate. This night, as in other instances, as my colleague Ms. Bergolo will show you in a bit, the victims were subjected to repeated, lengthy mistreatments by the accused and his co-perpetrators with the aim to inflict maximum pain. At the same time, they were humiliating and accusing the victims to be spies and collaborators and interrogating them on these baseless accusations. The perpetrators continued their abuse in spite of the visible injuries, the blood, and horrendous conditions of their victims who fainted, some of them falling in and out of consciousness. As pointed out in the SPO's final trial brief in paragraphs 349 to 355, this also qualifies their mistreatments as torture. All of this evidence on the 20 May 1999 incident is amply corroborated as set out in the SPO's final trial brief, section D. In particular, the accused's participation in this incident. First and foremost, the accused himself has made partial admissions concerning his participation in this very incident. He specifically admitted to beating two of the victims, as set out in paragraphs 204 to 206 of the SPO's final trial brief. In addition, trial witness 1, 1448, and 4733 all corroborate repeatedly the presence of the accused that night and his violent contribution to the mistreatment of each of them. 1448 stated that Wolf, he hit us all. The defense tries to cast doubt on the fact that trial witness 1, 1448, and 4733 witnessed each other's martyrium during that night. In particular, by pointing to alleged differences in 4733's testimonies in their final trial brief, paragraph 132. From the details both trial witness 1 and 4733 recalled, and as discussed in paragraphs 135 and 140 to 141 of the prosecution final trial brief, it is clear that at that moment, they both were in the same room. At that point in time, 4733 had already been severely beaten up to the point where he lost consciousness. He was bleeding profusely from a wound on his head, and when shortly after he was taken out of the room, he had been reduced to a terrible state. given his condition at this moment, it is understandable that 4733 may have had some confusion as to the exact number of other victims who were in the room with him when he was mistreated. Unlike what is submitted by the defense, this does not affect the credibility or reliability of 4733's evidence. After being beaten in the office room on the ground floor of the command building, 4733, 1448, and the murder victim were brought upstairs into the detention room of the command building, while trial witness 1 was taken to the detention building. The 3 detainees remaining in the command building at that moment would join him there in the days afterwards. Let us follow them. We are leaving the command building and pass the large warehouses surrounding it. Across the courtyard of the command building, the detention building was situated in the middle of the premises. The detention building is the second main location where the victims of this case were detained and mistreated. You can now see a picture of how the building looked from its outside. In the inside, the detention building had 3 rooms. 2 rooms to hold detainees, marked on this sketch by trial witness 1 as room number 1 and 3. And 1 room to torture detainees, marked as number 2. On the photograph, we can see the window of room 1 going out on the courtyard, now circled in red on the sketch and the picture. Marked in green now is the entrance door to the detention building, leading to the corridor between room 1 and 2. Trial witness 1 marked it at the very same spot as trial witness 10 did in his testimony before your honors on 1st May 2023 at page 1055 of the transcript and marked on Reg 00950. In the detention building, the ordeal of the victims continued. The detention conditions in the detention building were inhuman. The detainees were kept in small rooms in unbearable hot temperatures. Access to water in tanks outside the building was dependent on the goodwill of KLA soldiers who kicked and stabbed them on their way to the tanks. A similar treatment awaited them when they needed to use the extremely dirty toilets. So they tried to limit the use of these facilities and rather stayed thirsty than to face further mistreatment. In room 1, there were up to 13 detainees, held at the same time, crammed into the space of a room with about 3 to 5 meters per side. There was no furniture. The detainees slept either on the broken concrete floor for a limited of time. They had some thin mattresses or blankets, or they would lean against the wall and using their hands as pillows. For them, food was scarce. Some days they were given a boiled egg, a fish, or leftovers of what the KLA soldiers had eaten. Some days they did not eat anything at all. They could not wash themselves or change clothes. 4733 remembered the other, that they smelled like animals. In room 3, at least 6 detainees were kept. With one exception, the detainees slept on the concrete floor, only some blankets to put on it. Differently from those detained in room 1, the detainees here were provided with food, even with only a watery soup. Some detainees were subjected to forced labor, to unload trucks, or cleaning the dirty toilets. In their final trial brief, the defense admits that the conditions imposed on the detainees at the Cook's Metal Factory were poor, but claimed that this was the general standard at the Cook's Metal Factory and that the KLA soldiers had to live in similar conditions. The list of allegedly comparable conditions for KLA soldiers in paragraphs 107 to 109 of the defense final trial brief does not even come close to what the detainees endured. The defense compares detainees kept against their will, defenselessly exposed to the whims of their tormentors, with KLA soldiers staying in the Cook's of their own will, and able to leave the Cook's Metal Factory whenever they liked and to cater to their own needs elsewhere. They compare starving detainees with KLA soldiers not having access to properly cooked food for several days, so they only had the choice to eat out of tins or dry food. They compare detainees frightened to use the toilets or to get water due to the harassment that awaited them on their way there, and only able to access such facilities with the permission of their captors, with the free access of KLA soldiers to sanitary installations, even without doors. They compare detainees crammed into a small room where they could not stand upright or lay down at the same time, on nothing but a few blankets, with KLA soldiers free to move around, resting on mattresses and sleeping bags. To justify the misery imposed on the detainees, the defense also resorts to a general supply issue, naming specifically shortages of water and electricity. The miserable conditions imposed on the detainees at the Cook's Metal Factory were not dictated by any external factors, but intentionally set and maintained. The hardships were imposed on them by the perpetrators, who decided to hold them in unsuitable rooms, in unbearable temperatures, without any possibility to rest, and to make their access to water supplies or sanitary facilities a gauntlet. The defense's claim in paragraphs 110 and 111 of their final trial brief that detainees at the Cook's Metal Factory generally had access and were provided with medical care is a mischaracterization of the evidence. There was indeed an infirmary and medical staff at the Cook's Metal Factory. That care, however, was not available to the detainees, or in the rare cases they received treatment, it was forwarded by the certain KLA soldiers, despite horrific injuries sustained from beatings. So when the deep wound inflicted on 4733's head during the 20 May 1999 incident was bandaged, for example, the KLA soldiers torturing 4733 immediately cut the dressing off. 4733 was bandaged a second time, but the bandage was cut again. Also, the medication 4733 received for his diabetes was immediately taken away from him by KLA soldiers, although they were aware of his condition. None of the injuries the victims suffered during their mistreatments were treated properly, leaving the victims with lifelong impairments. I will come back to that later. For the murder victim, the denial of medical care had fatal consequences, as my colleague Ms. Bergolo will outline later. In any event, generally poor circumstances and shortages of resources cannot justify inhumane detention conditions. If anything, they rather demand the release of detainees. The extraordinary chambers in the courts of Cambodia held in their trial judgment in case 002/02, dated 16 November 2018, in paragraphs 734 to 739, citing also the ICTY jurisprudence, that even when the circumstances at the time of the commission of the crimes are difficult due to shortages of resources, resources which are nonetheless available should be provided and countermeasures adopted to mitigate the impact on the victims. There is a minimum standard of treatment which needs to be guaranteed in any circumstances. If this is not possible, victims should not be put in position which exposes them to the violation of their basic rights. In addition to the miserable conditions and specific incidents of 20 May 1999 just discussed, or the mistreatments my colleague Ms. Bergolo was going to touch upon shortly, the detainees in room 1 of the detention building were beaten, harassed, sleep deprived, and threatened almost every day. Just to give you a few examples, during these mistreatments, trial witness 11 was punched so hard in the eye that the blow still affected his sight in the year 2023. 4733 was kicked in his mouth, breaking his teeth. 3 Roma musicians from prison were beaten as if they were animals, in the words of 4733. And trial witness 1 was beaten up so severely that when he was brought back into the unbearably hot room 1 of the detention building, he was seen shivering. The detainees were made to beat each other, including on their genitals. They were deliberately made to witness the mistreatment of their co-detainees in the detention room, and they could hear the screams of detainees beaten outside of room 1. Detainees returning from the harsh interrogations they were routinely taken out for showed signs of beatings. Throughout this trial, Your Honors have heard how the victims suffered from the inhumane detention conditions and severe mistreatments, how degrading it was, and how severe the physical and mental harm was. Some of them are still suffering from this today. Their evidence establishes beyond reasonable doubt that the accused and other KLA members subjected those detained at the Cookers Metal Factory to cruel treatment and torture. The walls of the detention building saw incredible violence and a horror beyond words. While the victims of the events charged in this case suffered a lifetime from the ordeals they went through at the Cookers Metal Factory, the detention building itself no longer exists. This picture shown to you and now visible on the screen was taken in 2009. Since then, the building has been demolished and the detention rooms were made to disappear. Today, only a small part of it, now visible in the big picture on the screen, in brickstones at the very back of the right picture, is left. We heard a number of defense witnesses throughout this trial who did not remember this detention building. Let's have a look and go back to the aerial view of the premises. on the aerial photograph, we can see that the ground on which the building stood still shows the shadow of the detention building that once was there. The blueprint of the Cookers Metal Factory, now visible on the left side of the screen, leaves no doubt about the existence of this building and its dimensions. If we align both the blueprint and the aerial view northwards and put the blueprint over the aerial photograph, a building appears aligning with the remaining parts of the detention building visible on the aerial photograph, and with the same specific staggered contours as seen on the photograph taken from its front in 2009. In the middle of the courtyard, between the warehouses amply used by the KLA, besides their toilet facilities, impossible to overlook, and just as described by the victims. Are we taking a break? I'm now handing over to my colleague, Ms. Bergolo, who will talk about two specific incidents charged in this case.
Thank you, Madam Prosecutor. We will continue as we used to do till 11 o'clock, and then we will have a break a little bit before or a little bit after, just how it fits with your presentation.
Good morning, Your Honors. Good morning to everyone in and outside the courtroom. I will continue our presentation on the crimes and locations by discussing two incidents which have been charged in this case as cruel treatment, torture, and murder. For Your Honors and the other parts and participants' reference, the parts of our final trial brief relevant to these topics can be found in section 5E and 5F. I will not repeat the detailed account of these incidents that is set out in our brief. I will just give a brief summary overview of them. I will then address specific challenges raised by the defense in relation to these events. And in order to comply with protective measures that have been ordered by this panel, I request that we move into private session for this part of my presentation. The accompanying visual presentation, Your Honors, also should not be broadcasted to the public.
Madam Prosecutor, your request is to go now into private session?
Yes, Your Honors, please.
Very
Thank
well.
you very much.
Could you please bring us into private session
Your Honors, we are now in public session.
Thank you very much. Madam Prosecutor, I understood from your submissions that the next part will take 30 minutes. So what we will do is to have a break now for 30 minutes till 10 minutes past 11, and then we will proceed. Yes? The hearing is adjourned.
All rise. All rise.
Please be seated. Welcome back. Let me see. Can you confirm that there have been no changes? No, that's easy. And on this side? the
Yes,
defense
a
counsel?
tiny change.
Please, you have the
Your
floor.
Honor, we have with us Ms. Anouk Pinault, a legal intern. Thank you
well.
very much.
Thank you. Mr. Shala, welcome. Can you hear me fine?
Yes, I can hear you very well.
Very well. Before I give the floor to the Specialist Prosecutor's Office, the planning for this morning, we will be proceeding for 1.5 hours, in principle, unless the submissions ask for a new change. And then we will have a break, and depending on when we stop for lunch, I will see how long the lunch break will be, so that in the afternoon we can have 2 sessions, but we always need to have a small break in between if we have 2 sessions. So I take it as it comes. Yeah? You have the floor, Madam Prosecutor, and if you want me to go into private session, please tell me so.
Yes, Your Honors, please, if we could move into private session. Thank you.
Very well. Madam Court Officer, can you bring us into private session, please?
Your Honors, we are now in public session.
Thank you. Madam Prosecutor, you may proceed.
Your Honors, in this next part of my presentation, I will address matters concerning the credibility of the witnesses who testified in this trial. First, I will deal with the allegations of influencing and collusion between SPO witnesses. Second, I will make some remarks on the credibility of the evidence provided by the defense witnesses. In their final trial brief, at paragraphs 257 to 263, the defense references the evidence of some SPO witnesses that they met after the war, which they themselves relate, and argues that it is likely that the witnesses discussed material facts in this case. The defense implies that these discussions led to the witnesses influencing each other's evidence. First, these submissions are entirely speculative. The defense offered no evidence that these normal interactions undermine the truthfulness and the credibility of these witnesses' evidence. Indeed, the fact that certain discrepancies exist in the evidence of the witnesses shows that their accounts are genuine and personal, and that there was no attempt to agree on one version of the events to provide to the investigators. These discrepancies, which do not affect their credibility, are due to the different experiences of the victims, to each individual victim's personal recollection of certain details of what happened at the Kukes metal factory, which differs from that of the others, and to the passage of time. We have provided some examples of these discrepancies in our final trial brief, Your Honors. For example, at paragraph 131 and footnotes, or 233, so I will not repeat this here. Second, the defense claims that the presence of trial witness 7 during the 2009 ULEX interview of 4733 evidently influenced his evidence. Your Honors, this claim is simply bizarre. Trial witnesses 7 knowledge of the plight of 4733 comes from 4733 himself. And that's the reason why the SPO called trial witness 7 as a witness in this case. What trial witness 7 heard during that interview was nothing new to him. Finally, Your Honors, the defense also alleges that trial witnesses 6, 7, 8, and 9 came to an agreement on names to mention in their testimonies. And this is because they all refer to a person called Imer Imeri. Your Honors, when it comes to these witnesses, the fact that they may have discussed the events that befell them, and they may have remembered certain information in a similar way, is not a surprise. As Your Honors know, their knowledge of some of these events is indirect, and it comes from the same source. However, this does not mean that they came to an agreement as to what they would say during their testimony. There is no evidence that they were not sincere, nor any discernible reason why they would be. I will turn now to the defense's attempt to manufacture allegations of collusion in respect of trial witness 1 and trial witness 10. This is also entirely unfounded. First, the defense claims that when the accused was arrested in 2021, trial witness 1 changed his story and stated that it was the accused who took him to Kukes in order to falsely incriminate him. However, this is based not on the evidence of the witness, but solely on an official note from March 2021. The defense put this alleged inconsistency to the witness during cross-examination, and he explained that he had never said that it was the accused who took him to Kukes during the March 2021 conversation with the SPO. We don't know what exactly was said in that conversation and how the information conveyed by the witness was understood and reported by the person who drafted the official note. Clearly, what is at issue here is a simple error, and most likely one that is not attributable to the witness, given that when presented with the note at trial, he corrected the information. The record is at odds with the defense allegation. If trial witness 1 intended to change the evidence he had provided before, why would have he then changed it back again at trial? Second, the defense also points to the fact that in 2022, trial witness 10 told the SPO that Pieter Shala took trial witness 1 and his companions to the Kukes metal factory. Both trial witness 1 and trial witness 10 testified in court that it was another individual who took them there. This is, in the defense's view, clear evidence of collusion between them. Your Honors, trial witness 10 testified that the accused came to the Kukes metal factory 15 to 20 minutes after trial witness 1 and his companions arrived there. So he placed the accused at the Kukes metal factory at a time temporarily close to that transfer. This is not very different from what he had stated in 2022, that Pieter Shala, who had arrived shortly after trial witness 1 and the others, who was also involved in their transfer there. Trial witness 10 testified that he did discuss these events with his friends. This is a normal occurrence among people who live in the same town. But the defense did not challenge the witness on what he stated about the accused, trial witness 1, and the other individual involved in the transfer. They did not seek clarifications in this regard in cross-examination. They chose not to ask any questions on this topic, depriving trial witness 10 of the opportunity to clarify. Other aspects of the identification of the accused at the Kukes metal factory provided by trial witness 10 are corroborated by the accused himself, who stated that he was coming and going to and from the Kukes metal factory throughout the indictment period. The testimony of trial witness 10 on the accused's presence at the Kukes metal factory is therefore corroborated by the accused himself. It is credible, and it is particularly reliable in light of the witness's tasks at the time. I will now make some remarks on the credibility of the evidence provided by the defense witnesses. We have made detailed submissions on this topic in our final trial brief in section A, paragraphs 240 to 307. So I will not repeat what we have included in the brief in this context. I will just make a few observations. In assessing the credibility of the defense witnesses, Your Honors, you should consider what they said in relation to the commission of crimes at the Cookes Metal Factory, or the lack thereof, and in particular, what they said about the detention building. In this regard, Ziadin Oja, Nasser Kocinai, and Mark Shala all denied even seeing the detention building during the time they spent at the Cookes Metal Factory. Ziadin Oja, a KLA member in charge of weapons maintenance during the indictment period, claimed that his view of the premises was obstructed by the presence of trucks, and so he did not see, among other things, the detention building. This is despite him working at times in the courtyard, just outside the food warehouse, and walking across the courtyard to reach the command building. Nasser Kocinai was based at the Cookes Metal Factory between March and June 1999 and worked in the uniforms warehouse. Kocinai was asked to confirm that he never saw the detention building, even though it stood in the middle of the courtyard, which he crossed every day to go from the entrance gate to the warehouse. He claimed that he didn't remember. He said, and I'm quoting, "I didn't look around. I just went to my workplace. I wasn't interested in other things." The implausible and evasive nature of these assertions are evidently a way to distance himself from the crimes committed just a few meters away from where he was working. Mark Shala was the chief of logistics for Operation Arrow. He was based at the Cookes Metal Factory from early April 1999 until the end of the war. He testified before this panel that he didn't remember the detention building being there at the time. We have illustrated in our brief why this claim is not credible. And I refer your honors to paragraph 255 of our brief. What I would like to draw your attention to here today is the absence of the detention building from the sketch he made of the Cookes Metal Factory. During his testimony, Mark Shala explained that his sketch identifies the building that were in use by the logistics sector, stating that there may have been other buildings behind those that he marked. But he made no mention, nor did he draw, the long building protruding inside the courtyard, in the middle of it. The building that you would have had to pass by to get to the toilets. He testified he sometimes used. The same building that he would have to pass by on the way to the dormitory warehouse, where he said he went whenever he had time. And Your Honors, I will now make use again of a visual presentation to illustrate this point, and this presentation can be broadcasted to the public. In this first slide, we see, again, the 1996 blueprint of the Cookes Metal Factory, which was illustrated by my colleague, Ms. Wheeler, earlier, with a particular focus on the buildings, and in particular of the detention building that we see on the left-hand side of the small red square. I will now show in the following slides the sketches of the Cookes Metal Factory drawn by 3 different witnesses vis-à-vis the blueprint. In this slide, we can see now the sketch prepared by witness 1448. And he drew his sketch exactly in the same perspective of the blueprint, where we see the command building on the top right-hand side of the drawing, which corresponds again to what is building number 1 in the blueprint. Then we see what he called Magazzina on the left upper corner, which corresponds to building number 2 in the blueprint. And on the bottom, we see a building, the detention building, which stands in the middle of buildings marked with number 2 and 4 in the blueprint. Moving on to the next slide, we now see another sketch, this time provided by trial witness 2, also next to the blueprint. Trial witness 2 sketched the premises from another perspective. So we see the entrance marked with number 1, the command building marked with number 2, what he marked as the canteen or kitchen as number 6, and then on the right-hand side of his sketch, between 2 magazzinas, 5 and 3, again, the detention building. So his sketch is drawn from a different perspective than the blueprint, but I think that it is very clear, again, in showing the presence of this building. I will then move to the next slide, and here we have the sketch provided by trial witness 1, also close to the blueprint, also drawn from a different perspective than the blueprint, but the same perspective of the previous sketch. Again, we have the entrance, the command building on the left-hand side, kitchen, the clothes and the food warehouses, another building on the right-hand side of the gate, and again, the detention building with 3 rooms. Trial witness 10, a KLA member who was also based at the Cookes Metal Factory during the indictment period, It is keeping this in mind that we ask the panel to assess the evidence provided by the defense witnesses. This, Your Honors, concludes my part of the presentation. I thank you for your attention, and I leave the floor to my colleague, De Minicis, who will continue from here.
Thank you, Madam Prosecutor. I give you the time to swap places.
In this regard, Your Honors, my presentation is divided in three parts. The first one may last approximately 40 minutes. Now, before I start with that, I have a short introduction that will take a few minutes. Perhaps I could limit myself to the introduction right now, and then we could take the break, or we can continue past the time that we would continue this session, which would be 12:30 or 12:40.
And my intention was 12:40.
Okay, well then I could actually finish by then. Yes.
Okay, you have the floor.
Your Honors, the accused's responsibility in this case is established beyond reasonable doubt by multiple sources of evidence. The witnesses who directly implicate him in the crimes are mainly, but not only, trial witness 1, 4733, 1448, and trial witness 10. Their evidence is mutually corroborating and strongly corroborated by the evidence of the accused, as we have set out in detail in section 5H of our brief. While the accused made admissions about his participation in some of the charged crimes, his admissions are only partial ones. They are limited to what he thought he had to admit to come across as credible while trying to avoid prosecution. In paragraphs 208 to 214 of the prosecution brief, we have again set out in detail the numerous contradictions in his statements. I will make but just one example, which is his denial in 2009 and 19 that the KLA was looking for 4733 in 1998, when in 2016 he had stated the contrary, including expressing his regret for not having found 4733 in 1998. The defense has decided to remain silent on the accused statements. The defense brief is replete with claims that there is no evidence of the accused's participation in or knowledge of detention and mistreatment, in spite not only of reliable witness evidence to the contrary, but of the accused's own statements. The defense claims in paragraph 340 of the defense final brief that it is unclear whether the accused's 2016 and 2019 statements will be used in the panel's deliberations. This is an untenable claim, which is contradicted by the panel's clear indications that they will be used. In its decision of 20 April 2023, F00491, at paragraph 41, the panel unambiguously stated that it considers the 2016 and 2019 accused prior statements to be available to the panel for the purpose of its judgment, subject to the determination by the Court of Appeals panel, which later, as we know, upheld the decision. The defense is within its rights to remain silent about the accused statements if it chooses to do so. But the record should be clear that there was never any uncertainty as to their availability for the panel's deliberations. Now, in the submissions that I will be making for the next 45 to 60 minutes, I will first discuss the timeline of the accused presence at the Cookers Metal Factory, what we know for sure about his presence and his participation in the charged crimes. I will then address how this participation makes him responsible under the modes of liability charged in the indictment. I will address some defense challenges in that regard, both challenges of law and of fact, and I will make some further submissions to those we've already made on the issue of murder intent. Finally, and I'll do that for last, for the reasons I explained at the beginning, I will address the credibility of trial witness one. Let us now start with the presence of the accused at the Cookers Metal Factory with the assistance of a simple timeline I have prepared for this occasion. And Your Honor, if you can just give us a second to load it up. Now, Your Honors, we know this from the accused's own statements, also from statements, by the way, that Your Honors specifically admitted in evidence, those from 2005, that he arrived at the Cookers Metal Factory around 22 or 23 March of 1999. We know this from his own statements. He speaks about it in several statements. This is just two. The first one is from 2019. The second one is a statement from 2005. Now, in his 2016 and 2019 statements, the accused stated that upon his arrival, he stayed at the factory only a few days and then left for the front lines to find Fatmir Lemay, also known as Cheliko, who was preparing to attack. The defense adopts this narrative in their brief, although without referencing the accused statements. This story, Your Honors, is different from what the accused stated in 2005, which we submit is what actually happened. Your Honors, in the second half or end of April 1999, the accused moves to Burrell and he is arrested in the context of the killing of a soldier, Halil Gashi. We know from the accused's 2005 statement that upon his arrival in Cookers, he remained there until another group came and we were sent to Burrell for training. We know from page 32 and following of that statement that there he was arrested in connection with the killing of a soldier. We know from pages 39 and 40 that he was then released, according to the accused, because his cousin was a commander. We submit that that is a reference to 4754. Now, this account, Your Honors, is consistent and further details are provided by other witnesses. For instance, 4848, 4754, and defense witness 2. From the account of these witnesses, we know when the accused went to Burrell, which is in the second half of April, end of April 1999, and until when he remained there, which is at least until the 2nd of May 1999, the day where Halil Gashi was killed. The defense stated that that's a fact of public knowledge. We know that the accused went there with Rusdi Saramati and his men. We know, in fact, that Rusdi Saramati and 2 military policemen were arrested for that killing, and we know from 4754 that the accused was member of a military police platoon at that time. So the accused, Your Honors, did not leave for the front lines as soon as he arrived. He waited in Kukës and went to Burrell. Burrell is not at the front lines. It's a town about 100 kilometers southwest of Kukës, towards Tirana. There is also another detail, which we know from the evidence of 4754, that Fatmir Limaj was appointed as commander of Operation Arrow and arrived in Albania from Kosovo in mid-May 1999. So the accused setting off to meet Fatmir Limaj at the end of March, Fatmir Limaj, who was about to attack at that time, it just doesn't fit. Why is this important? For two reasons. First, it shows that the accused was not truthful about his whereabouts once he was informed through a summons he received towards the end of 2015 that he was suspected of crimes committed in Albania in 1999. Second, because this detail affects the credibility of 4754, a defense witness, about the timing of his meetings with the accused at the Kukës metal factory. And I will get to this point in a second. We're now in May 1999, Your Honors, and the accused went back to Kukës after he was released for the arrest and to the Kukës metal factory. We know this from several sources. First, we know this from 4754, who stated that he met the accused at the Kukës metal factory and he issued him a sniper rifle after, he recalled that very clearly, after he had come back from Burrell. While 4754 testified that the meeting took place in mid-April 1999, it must, in fact, have happened in May, because of that reference to Burrell. And for more details on this and on the contradiction between the witness's trial evidence and his prior statements, I refer Your Honors to paragraphs 246 to 249 of the prosecution brief. Second, we know that the accused was at the Kukës metal factory about 3 days before what we have consistently referred to as the 20 May 1999 incident. The relevant evidence is set out in paragraph 55 of our brief, and during this time the accused was going in and out of the factory, a detail which, as set out in paragraph 52 of our brief, matches the evidence of the accused and is corroborated by a KLA soldier who testified in this case. So, Your Honors, in the days immediately following the 20 May 1999 incident, the accused was around. He was in Kukës, and he was going in and out of the factory. We're now on the 20th of May, on or around. On this day, the accused took part in the transport of 4733 from Romanat, just outside Durrës, to the metal factory. This incident is discussed in section 5A3 of the prosecution brief. Sadly, 4733 passed away before he could testify in this trial, but his statements concerning the accused's participation in his transport are reliable, consistent, and corroborated. They are reliable because the accused, 4733, knew the accused, knew who he was, he didn't know him personally, from his work as a police officer. As set out in paragraph 217 of the prosecution brief, the accused was a person of interest to the police. And 4733 saw his picture in a photo album when he was working as a policeman. in part 1 of his SPO interview, pages 37 to 38, 4733 explained that the Serb police had a file on the accused. That's how he knew of him. The accused, by his own admissions, and this is in paragraph 44 of our brief, had been convicted and had served time in the 80s. And in the 90s, he was conducting armed actions against Serb police installations. The accused criminal record that the SPO has obtained from Serbia shows that in December 1996, the accused had accumulated 2 criminal convictions, including in relation to possession of weapons. This, Your Honors, explains why the Serb police would have a file on him, as consistently explained by 4733 in the statements he gave over time. The defense, in their brief, argued that certain witnesses, and I'm referring to paragraphs 238, 246, and 247 of their brief, certain witnesses contradict 4733's evidence that he knew the accused before the war. They don't. None of the evidence cited by the defense actually contradicts this part of his testimony. 4733 may not have talked to these witnesses about it, and these witnesses are not to be expected to know all of the persons that 4733 was familiar with by virtue of his work as a policeman. In fact, if 4733 knew who the accused was, the accused knew who 4733 was. They were familiar with each other by virtue of their own occupations at the time. By his own admission, the accused knew 4733's name, his village of origin, and that he had been a policeman. He even knew that in 1998, 4733 was no longer a policeman, which fits the evidence of 4733, who stated that he had been dismissed from his job at the end of 1997. And this evidence can be reviewed in paragraph 218 of the prosecution brief. Contrary to the defense submissions, 4733 did not give an entirely inaccurate description of the accused appearance. 4733 described him as a big man with a head full of hair, dark eyebrows, and a big face. He stated that he had a dark complexion, almost black, but that can be attributed to the quality of the photo, the lighting, or the exposure to the sun while laboring outdoors. We did not see that photo, and we don't know. We know, though, that the rest of the description is accurate. There's more, though. For 733, he is a big man and he does have a head full of hair. That is the part of the description we are referring to, Your Honors. There is more, though. 4733 stated that the accused looked different from what he remembered when he saw him in the van. He was sincere about it, but when the accused howled like a wolf, 4733 knew that he was him. The howling, Your Honors, is something that the accused himself admitted doing, and that 4379, a witness who met the accused at the factory, distinctly remembered him for. And, Your Honors, despite the defense submissions to the contrary, howling is a rather unique and therefore identifying feature for a human being. Finally, on reliability, 4733's evidence that the accused transported him to the factory on that day is reliable because only a few hours later, only a few hours after that transport, the accused was still there at the factory to participate in the 20 May 1999 incident, as we know from multiple sources. Now, 4733's statements are also consistent on this point. Since 2010, 4733 has always implicated the accused in his transport for Romanat from Romanat, near Durres, to the factory. He testified to this effect during the trial against Sabit Ghezi, where Peter Shala was not an accused, and repeated it during his SPO interview. In this regard, the defense argues that this account is not credible because 2010 is the first time that he mentioned the involvement of the accused, that 4733 mentioned the involvement of the accused in this incident. But differently from what the defense argues, Your Honors, 4733 had not actually discussed the specifics of that transfer in his previous statements, certainly not in great detail, as submitted by the defense in paragraph 232 of their brief. In fact, from the 2003 SEDY statement, also relied on by the defense in support of this contention, it's actually evident that 4733 was not asked any question at all about that transport. Lack of mention of the accused involvement in this incident, therefore, in these statements, does not undermine what 4733 said consistently from 2010 onwards. Finally, Your Honors, 4733 statements are corroborated. They are corroborated by the accused himself. As set out in paragraph 207 of our brief, the accused stated that he had learned accusations against 4733 in the Durres camp. This is where 4733 had been detained right before his transport, to which the accused participated. The accused admitted that he had been there and that he had learned the details of the accusations against 4733. This, we submit, is corroboration, direct corroboration of what 4733 said. Your Honors, we remain on 20 May 1999, on or around, for what happened afterwards. I won't repeat the details of that incident, which has been discussed at length by my colleagues, and we have dealt with it in detail in our brief. But I will address some defense challenges in that regard. I will just remind Your Honors that his presence of that night, during that night is proved by the mutually corroborating evidence of three witnesses: trial witness 1, 4733, and 1448, discussed in sections 5D and 5H3 of the prosecution brief. It is also corroborated, amply corroborated, by the statements of the accused himself, as discussed in section 5H1 of our brief. I won't repeat the evidence, but now I'll address the defense challenges. Now, the defense argues throughout the defense brief that trial witness 1's evidence is not credible, that it's a fabrication concocted with the intent to deceive, and I will address these challenges later today, as I've explained. For now, I'll just note that trial witness 1's identification of the accused is highly reliable, for the reasons set out in paragraph 202 of our brief. His evidence is also corroborated in detail by that of 4733, who, as we have seen, knew the accused, knew who he was, and his identification is reliable. The defense attempts to cast doubt on 4733's identification of the accused during that incident by attacking the identification he made of other individuals. We have addressed some of these challenges in our brief, in paragraphs 296 to 307. What matters, though, in particular for this incident, is that when it comes to the accused, 4733 has consistently always implicated him in his mistreatment. And this evidence on this point matches that of trial witness 1, 1448, and of the accused himself. There is just this coming together of different testimonies who put him there that night with a level of detail, Your Honors, that can only be explained with the fact that they're telling the truth. 4733 recalled that on this occasion, the accused had told him that he had been looking for him in 1998, a memory that, as we know, 4733 had also shared with other people after his liberation, as it's discussed in paragraph 218 and 11 of our brief. As we set out in paragraph 212 of our brief, the accused 2016 statement corroborates this evidence. The accused, in fact, not only acknowledged that the KLA was looking for him in 2018, but added, if I had caught him 1 year earlier, he wouldn't have been able to testify about anything anymore. Unfortunately, I never found him. Notice these are his words, a statement that he had the opportunity to reread and sign. The evidence of 4733 about the accused participation in the 20 May 1999 incident is also corroborated by trial witnesses 6, 7, 8, and 9. The existence of some minor differences in their evidence does not make it incredible. The defense, for instance, repeatedly addresses one supposed inconsistency of trial witness 8, who stated that 4733 was electrocuted in Cookes, while in fact 4733 testified that this had happened earlier.
Now it has been corrected. Thank you.
May I proceed, Your Honors?
Please proceed.
Now, the fact that he learned the identity of the accused from the source indicated by the defense in paragraph 14 of their brief does not make his identification any less reliable. In fact, Your Honors, it makes his identification very reliable because the source knew the accused very well. Also, the source told 1448 who the accused was, who the person who beat him was, at the time of their detention. It's not that they talked right before the trial. They told him, they discussed this at the time of their detention, so there can be no suggestion that he was trying to improperly influence a future witness when, Your Honors, these people didn't even know if they would have made it out alive of that prison. Last but not least, Your Honors, the accused himself corroborate all these witnesses as set out in paragraph 206 of the prosecution brief. Now, Your Honors, we know from the accused statements that he must have been, again, at the Cookus Metal factory at some point between 20 May and the 1st of June, 1999. Ostensibly on this occasion, he was there to restock on ammunition for his rifle. He stated that his rifle had used a rare type of ammunition, which was heavy, so he kept his reserve stock at the Cookus Metal factory, and when went out in the field, he only take a few bullets with him, and then would come back to get more. On this occasion, the accused said that he saw 4733 in the common building wearing a camouflage uniform, serving coffee to KLA commanders. Now, we don't know whether the circumstances of this meeting are exactly what they are, but we know that the accused that 4733 was made to wear a camouflage uniform after his arrival at the Cookus Metal factory. He first, during the transport, when the accused transported him, he had a black uniform on. They had put him on him to disguise him as a KLA military policeman in case the Albanian police stopped them between Romanat and the factory. After that, we know from 4733 himself, he was made to wear a camouflage uniform. And that's exactly what the accused says he was wearing when he sees him there in the command building. This also matches the evidence of 4733, who said that in one instance when he was in the common building, he saw the accused. And it was about 4 days before his liberation. So whatever the exact nature of this sighting by the accused was, this directly contradicts the defense claim in paragraph 8 of the defense brief that the accused was not present at the Cookus Metal factory in late May 1999. It's proof once again that the accused has not been truthful about his whereabouts and that he has tried to distance himself from the Cookus Metal factory during the indictment period as much as he could, or as he thought he could. We're now at the last point of the timeline that I'm presenting to Your Honors. And we know that the accused is again at the Cookus Metal factory on or around 3 June 1999, the day when the accused participated in the incident described in detail in section F of the prosecution brief. We know that this evidence comes from trial witness 1, and I will make some additional submissions on his credibility later. But for now, I want to point out that his evidence on this point is corroborated by witness 4379, the Albanian man who had granted to the KLA use of the Cookus Metal factory, as discussed in section 5F1A of our brief. Now, the defense quoted 4379's evidence in their brief somewhat selectively, stating that 4379 had met the accused at the factory after the war. The witness actually says that in one line of the several pages in which he talks about this meeting. I will talk about the other lines, those that the defense has now relied on. A complete reading of 4379's evidence reveals that he met the accused at the factory before the end of the war, when the accused had transported to Cookus those wounded and killed in the shelling of Gorozub. We know from another defense witness, Your Honors, 3887, whose evidence is discussed in paragraph 28 of the prosecution brief, that this shelling took place on 31st May 1999, with the funerals of the victims taking place between the 1st and the 4th of June 1999, and attended by a large number of soldiers who then returned to the front lines. 4379 has also sadly passed away not long before he could testify in this trial. We're not asking Your Honors to rely decisively on his evidence to find that the accused was at the factory at that time. Trial witness 1, his evidence is the main source of the accused's presence. But 4379 does provide strong corroboration as well as other evidence of motive that I will discuss later. Now this, Your Honors, concludes the SPO timeline of the presence of the accused at the metal factory and of his participation in the crimes as it emerged beyond reasonable doubt from the evidence. I will now address how this participation makes him responsible as a participant in a joint criminal enterprise. I will not repeat all the submissions that we have made in our brief, but I will address certain defense challenges to his responsibility. We'll just summarize how the SPO has framed this responsibility. Pietro Shala is responsible, alleged to be responsible for these crimes as a participant.
Mr. Prosecutor, I'm looking at the time.
Oh, yeah, I'm sorry. Yes, yes, I got it a bit ahead of myself. I didn't see the clock. I think we should stop now and then proceed later.
Thank you. Thank you. Yes, we are now in public session. I will set our lunchtime for today till 1:45. Then we have 1.5 hours of hearing, a quarter of a break, and then another half an hour, and then we close at 4. Yes. Very well. I wish you good lunch, and the hearing is adjourned.
All rise.
Please be seated. Welcome to everybody. Let me see. The SPO is in the same composition. Thank you also for Victims' Counsel's team and the defense.
Yes, Johanna, you have one more time changement. And we have with us Ms. Corali Juber-Vela, a legal intern. Thank you very much.
Very well, thank you. Welcome, Mr. Shala. Can you hear me fine?
Yes, I can hear you fine, thank you.
Again, to the Specialist Prosecutor's Office. Mr. Prosecutor, you have the floor, and please inform the panel when we have to go into a private session. Thank you.
And Your Honors, this is at the start. We want to inform you that we are likely to finish today with our submissions.
Thank you for informing us.
So, before we took the break, I was about to embark on my submissions on the responsibility of the accused as a participant in a joint criminal enterprise. The JCE, as described in the indictment, had a common purpose, which was to interrogate and mistreat detainees at the Cookes Metal Factory. This common purpose involved the crimes of arbitrary detention, cruel treatment, torture, and murder. The accused is charged with having significantly contributed to the furtherance of the common purpose and to have possessed the intent to commit these crimes. Members of this JCE, in addition to the accused, included Jamshid Krasniqi, Sabit Gezi, and other KLA soldiers as policemen, including those identified as Badri and Van Damme. Evidence of the existence of this JCE and of the accused's responsibility for that participation is discussed in paragraphs 357 to 373 of the prosecution brief. I will now address certain defense submissions on this topic. I will start by addressing the defense submissions on the evidence of the existence of the common criminal plan described in our brief and charged in the indictment. In paragraphs 77, 81, and 144 of their final brief, the defense argued that the prosecution failed to prove that a group of persons, which included the accused, had agreed to adopt the common criminal plan charged in the indictment. It also argues that no evidence of any direct or indirect communications between the alleged JCE members was presented. The submissions, Your Honors, are premised on a wrong interpretation of the law governing JCE, but they also misstate the facts. For JCE liability to arise, Your Honors, there is no need to prove the existence of an explicit agreement. The prosecution does not need to prove that the plan has been previously arranged or formulated. The plan may materialize extemporaneously, and its existence inferred by the concerted actions of the JCE members. The accused participation, the 20 May 1999 incident, the participation of all the JCE members there and the accused as well. The incident discussed in section 5F of our brief, or the accused transport of 4733 to the Cookes Metal Factory, where he was to be shortly after interrogated and beaten. These are in and of themselves, as well as collectively, clear examples of this concerted action. Evidence of this concerted action also comes from the accused himself, as set out in paragraph 205 of the prosecution brief. The accused stated that he beat certain victims after being incited to do so by Sabit Gezi, another named JCE member. Now, the defense also argues that the accused did not participate in certain specific acts forming part of the crimes part of the common purpose. They make these submissions, for instance, in relation to arbitrary detention in paragraphs 82 to 86 of their brief. As Your Honors know, however, participation in a JCE need not take the form of the commission of a crime or of parts of the actus reus. What is required is that his participation contributes in some way to the furtherance of that plan, accompanied, of course, by the required intent. It doesn't matter, therefore, as argued by the defense in paragraphs, for instance, 48 to 59 of their brief, that the accused had no role in the release of the detainees, or whether he was responsible for them during their detention as argued in paragraph 83. It does not matter whether the accused held a particular rank, nor it matters how many arrests he took part in. In any event, Your Honors, even though the contribution need not be criminal per se, the accused did participate in the commission of crimes. We have by now repeated that multiple times, and we're talking about the evidence described in sections 5A3, 5D, and 5F of the prosecution final trial brief. Further, as set out in paragraph 363 of the prosecution brief, the accused's contribution to the criminal plan was significant. Now, with regard to the scope of the, please.
Mr. Prosecutor, I see that in the transcript we have not all the sections you mentioned have been written down. So
I'm happy to repeat them, and
if you could
I spoke
do
a bit
that?
too fast.
I think because we were dealing with numbers, it would assist.
Yes, by all means, Your Honors.
you would
I
repeat them.
referred to sections 5A3, that is the transport of 4733 from Romanat to Kukes, 5D, the 20 May 1999 incident, and 5F of the prosecution brief.
Yes, thank you, Mr. Prosecutor. And then I also see that you read out that, as set out in paragraph 363 of the prosecution brief, the accused's contribution to the criminal plan was significant. And then I see that something is apparently missing.
No, I think that's where my sentence stops.
Then
And I'm going to pick up from there.
very well. Thank you. You may proceed.
The defense, Your Honor, makes submissions also on the scope of the accused's participation in this JCE, observing that there is no evidence that he participated in certain crimes or that he mistreated certain of the victims. For instance, TW411. This can be seen, for instance, in paragraphs 112 to 120 of their brief. Your Honors, for the accused to incur liability for the crimes that are part of the common plan, it's not necessary that he participated in every aspect of that plan. Consistent jurisprudence on this point, rooted on case law dating to the aftermath of the Second World War, establishes that liability for participation in a criminal plan is as wide as the plan itself. Based on this principle, where the evidence establishes that a common criminal plan existed and that an accused made a significant contribution to it with the required intent, the accused is appropriately held responsible not only for his own contribution, but also for the actions of the fellow JCE members that were part of the criminal plan or that were foreseeable consequences of it. In fact, he's also responsible for the actions of people who were not, strictly speaking, members of the JCE, as long as these actions were carried out in furtherance of the plan. The jurisprudence on this is consistent and well established. I can recall, for instance, the Berjanian appeals judgment issued by the ICTY on the 3rd of April 2007, paragraphs 429, 431. When it comes to the scope of the accused liability, Your Honors, I refer you also to paragraph 423 of the Berjanian appeal judgment. Now, we've repeated, I have repeated a few times how a fundamental component of JC liability, of the basic form, is intent. The accused must have possessed intent to commit the crimes. And in paragraphs 363 and 364 of the prosecution brief, we discuss evidence of this intent. Evidence of his intent is conduct, Your Honors. His continued participation in the crimes, his deliberate participation in the beating of the detainees. It is, however, not the only evidence of it. His statements that he would beat his victims again without hesitation are unambiguous additional evidence of criminal intent. They are discussed in paragraph 405 of the prosecution brief. The defense submits that the crimes committed at the Cookers Metal Factory were motivated by personal revenge. While some of the witnesses have testified that, in their view, some personal conflicts with some of the perpetrators may have been the cause for their mistreatment, the fact remains, and the evidence is clear in this regard, that they were all accused, to different degrees and in different ways, of being associated with the Serb state. We have made numerous references to this evidence in our brief. I will just recall here, by way of example, paragraphs 58, 99 to 100, 133 to 134, 139, and 145. Now, that these accusations were levied against the victims, we know it also from the statements of the accused himself with regard to two victims, as set out in paragraphs 206 and 367 of the prosecution brief, and with regard to a third victim, 4733, as found in page 8 of the accused statement from 2016. In any event, Your Honors, even though there is evidence that the personal motives were not the reason for their mistreatment, any personal motives that they may have had are not determinative for his responsibility under the JCE as charged in the indictment. I will now specifically address the accused intent for murder. The evidence establishes beyond reasonable doubt that this intent existed in the mind of the accused and of the other JCE members. I refer Your Honors to paragraphs 366 to 372 of our brief. In this regard, I just want to recall something that Jamshid Krasniqi told two victims before they were shot. He told them that tomorrow only one of you will be alive, but not both of you. This can be found in the evidence of a witness in this trial. I won't say right now the specific number, I will say later. Now, for the additional submissions on intent, I need to move briefly into private session to give effect to existing protective measures. I will only need to remain in private for 2 to 3 minutes at this time, and then I will revert back into public. If we could move into private now, Your Honors.
Madam Court Officer, can you please bring us into private session?
Your Honors, we are now in private session.
Thank you, Madam Court Officer. Mr. Prosecutor, you have the floor.
Your Honors, motive is not an element of the war crime of murder. The SPO need not prove motive in order to prove discharge or the accused's responsibility, therefore. But evidence of motive, Your Honors, exists and should be considered by Your Honors when assessing the perpetrator's intent to kill. sections of Common Article 3 of the Geneva Conventions. And the accused himself stated that when he saw them at the factory, they did not pose any danger to the KLA. This is to be found in paragraph 205 of our brief. But the fact remains that they were accused of, they were labeled as having committed the highest form of treason. They were Serb combatants, essentially. They had fought with the Serbs. They had killed Albanians. It's this belief that triggered the accused and the other perpetrators' unrestrained level of violence against the victims. We know from trial witnesses 1 and 4 that soldiers would come back from the front line at night and unleash their anger against the detainees.
We are now back in public session.
Thank you. Mr. Prosecutor, you may proceed.
Your Honor, the intent to kill, as set out in the prosecution brief, emerges clearly from the perpetrator's course of conduct and words. I will provide a few examples. During the 20 May 1999 incident, at least 3 people were wielding unholstered guns. We're not talking about 3 people who had guns around their waists. We're talking about people who had guns in their hands. 2 of them used them to hit 2 of the victims on their heads, causing deep cuts and wounds. The soldiers also had and used sharp objects and knives. Now, people received strong blows on their heads and bled profusely, their clothes soaked in blood. They repeatedly lost consciousness, and then they were revived, beaten, lost consciousness again. This continued throughout the night. And despite all this violence, the accused continued to participate. During the 20 May incident, and then again in June. One 448, one of the victims of the beating, said that he never saw such tortures happening, not even in movies. Finally, on the night of the shooting, firearms were discharged in a way that leaves no doubt as to the existence of a murderous intent. Now, the defense position on this point is that certain changes in the detention conditions after the death of the murdered victim show that the perpetrators did not had the intent to kill. Well, Your Honors, actions taken after the fact do not change the evidence discussed above. Second, Your Honors, and importantly, it was not Jamshid Krasniqi who ordered the change of the conditions. It was Jaladin Gashi, Plaku, who was possibly the highest KLA officers there, who instructed the new guards to make sure that nobody would harm the detainees. We know this from the person who was instructed. The defense also argues that the accused was in no position to allow medical care to be provided, so any denial thereof cannot be imputed to him. Well, this circumstance, Your Honors, does not absolve the accused from JC liability for the murder. As discussed above, as long as he participated in a part of the plan with the required intent, he did not have participated in every single component of it. Although, Your Honors, in any event, the accused's relatively privileged position and closeness to some of the JC members makes it clear that he could have been at least able, it could have been within his power to try to assist the victim or to otherwise advocate for them. Not only he didn't do that, but years later, he said that he would repeat the beatings again. Now, Your Honors, the indictment also charges the accused in the alternative with murder under the third form of JC. That means that if he did not intend the crime, it was foreseeable to him that its commission might have happened. It's a possibility standard. In fact, as I have just described, the evidence presented at trial shows beyond reasonable doubt not only that it was foreseeable, but that there was intent to commit the crime. Each of the factors that I have listed leave no room for doubt in that regard. Your Honor, so I've now come to the last part of my submissions, which concern the credibility of trial witness 1. I will start in public session, but I will soon need to ask Your Honors to move into private session.
Thank you.
Trial witness 1 story about the plight that he suffered at the Cookers Metal Factory is credible. Your Honors, he knew the accused knew him. Although corroboration is not a requirement for an accused who testified live, his testimony is amply corroborated about the identity of the victims, the location of the detention, the type of the mistreatments, as well as the role of the accused. When his evidence is not directly corroborated, it's because the persons who could corroborate it could not come to testify at trial. The defense contends that his account is fabricated with a clear intent to deceive. They also argue that he lied to take revenge against the accused. Your Honors, I want to ask you, revenge for what? The only reason why trial witness 1 could feel resentment against the accused is his own criminal conduct. There is no other possible reason that emerges from the evidence, nor has any other reason been adduced. At this time, Your Honors, we need to move into private session.
Very well. Madame Court Officer, kindly bring us into private session.
I foresee having to stay there for about 10 minutes.
Your Honors, we are now in public session.
Thank you, Madam Court Officer. Mr. Prosecutor, you have the floor.
Now, the list of unsupported allegations against trial witness 1 continues. The defense accused him of openly discussing the proceedings with potential witnesses and deliberately fabricating evidence against the accused. This is to be found in paragraph 202 of the defense brief. The first purported example of this behavior, provided in footnote 449 of paragraph 202 of their brief, shows nothing improper in trial witness 1's behavior. Trial witness 1 knew that this person could be a witness of his suffering and wanted him to bear witness of that. To ask someone to come forward and testify is not evidence of improperly influencing a witness. In relation to the other witnesses listed in that footnotes, which should support that he deliberately fabricated evidence against the accused, the defense lists trial witness 2. If you look at the evidence they refer to, it's 060664 TRET, part 5, red 4, pages 2 to 3. It's really just an instance of one victim sharing his experience with another victim. There's no reference to the accused, nothing improper with that. Finally, the third witness, which should support the evidence that he fabricated evidence against the accused and by openly discussing the proceedings with other witnesses, is 1448. Now, this I've already talked about. Trial witness 1 telling 1448 at the time of their detention the identity of the person who had beat them up. It's nothing to do with trying to influence the proceedings. Nor is it evidence of trial witness 1 attempting to fabricate evidence against the accused. As I stated earlier, I think that at the time, a future trial was the last thing in the mind of these people who did not really know if they would have made it out alive of that place. Now, the defense also states that trial witness 1 failed to identify the guard that arrived when the conditions of detention finally changed. This is in paragraph 219 of the brief. But in fact, Your Honors, this is not true. What the defense refers to is a photograph of 4848, not of the guard they refer to in their brief. Finally, the story of trial witness 1's release. Your Honors, the story of trial witness 1's release is corroborated by witness evidence, a report about the events, and by 1448. What the defense points out to in paragraphs 225 to 226 of the brief are minor details that cast no doubt as to the place where trial witness 1 was held and then freed. Nor has the defense ever taken issue with that. Now, in conclusion, Your Honors, the evidence of trial witness 1 is both credible and reliable. His identification of the accused cannot be questioned, since the accused himself admitted to his interactions with him at the time. In addition, there is no evidence that trial witness 1 would have any reason at all to implicate the accused in something he was not responsible for. In fact, Your Honors, for this last comment, I will need to go again briefly into private session, with your leave.
Yes, of course. Madam Court Officer, kindly bring us into private session.
Your Honors, we are now in private session.
Thank you very much. Mr. Prosecutor, you have the floor.
Yes, Your Honors. In paragraph 229 of their brief, in their conclusions on trial witness one's credibility, the defense contends that his evidence shows a clear pattern of fabricating evidence with an intent to deceive. There is no, this is paragraph 130, sorry, there is no evidence of that. In paragraph 229, the defense contends that the witness saw in this trial
Your Honors, we are now in public session.
Thank you.
Your Honors, this concludes my submissions today, and the prosecution has established that the accused is responsible for the crimes charged in the indictment, and that this responsibility is based on credible and reliable evidence. I will now give the floor again to Ms. Wheeler, who will conclude the SPO submissions on sentencing.
Thank you. I will give you the time to swap places.
Thank you. The crimes committed by the accused warrant a severe sentence, reflecting their gravity, their severe consequences on the victims, the accused's role in them, the presence of multiple aggravating factors, the lack of any mitigating factors, and the importance of deterrence. With regard to the gravity of the crimes committed by the accused, they were undoubtedly brutal and devastating. Apprehended without any warning, torn out of their lives and families, at least 18 victims were illegally held in inhumane conditions at the Cook's Metal Factory, where they were physically and psychologically mistreated and tortured. You have heard about their ordeals earlier today. They lived in constant fear, and to say it in the words of trial witness 1, they were expecting to be killed at every moment. Indeed, one of the victims did not survive his detention at the Cook's Metal Factory. The accused's crimes took a terrible toll on detainees and their families. To the victims, the crimes inflicted on them caused far-reaching and long-lasting physical and psychological consequences. Trial witness 1 testified that he will never be able to leave behind the memories of what happened to him in Cook's, that he will never find peace of mind. To this day, he suffers from physical pain and chronic PTSD related to what he endured at the Cook's Metal Factory. Trial witness 11 still suffers consequences from the injury received to his eye, and more than 15 years after his detention, 4733's elbow and hand were still damaged, and his eyesight still impaired. He still suffered from anxiety and was haunted by nightmares, and years after his release, 4733 was still afraid and hesitant to visit the doctor in Kosovo for fear of being apprehended again. The accused's crimes also irreversibly traumatized the victims' families. Your Honors have heard the account of a victim family here in court. What befell on us will stay with us, and we will never be able to erase it, a victim's wife said. When her husband and the father of their children returned back home, he had injuries, wounds, and bruises all over his body. He was unwashed, smelled terribly, was pale, weak, and almost fainting. The victim was an important member of his family, a loving father engaged in the upbringing of his children. All of this changed after his detention at the Cookus Metal Factory, which left him as a completely different person. His trauma brought extraordinary distress, hardship, and suffering to his wife and children. With the mistreatment of my father, one of his sons said, we, as a family, were also mistreated. What had happened to their father and spouse affected the family as a whole. They were labeled as a family of spies, and they feared for their safety. 2 children had to stop to go to school. The victim used to provide for his family and now could not work anymore due to his physical and mental condition. At the same time, his medical treatments and surgeries were expensive and meant a high financial burden on the family, which then the victim's son had to bear. I spoke about aggravating factors. The gravity of the accused's crimes is further aggravated by the fact that the victims were particularly vulnerable and defenseless. Completely at the mercy of their tormentors, the beatings and fear instilled in them amplified their vulnerability and defenselessness. In addition to this, the accused and his co-perpetrators displayed a particular high level of cruelty against multiple victims. My colleague Ms. Bergel and I have touched upon the brutality unleashed on the detainees earlier in these closing statements. One of the victims was already in a bad state when he was detained at the Cookus Metal Factory due to an accident he had recently sustained. His injuries were evident to everyone, including the accused. The defense tries to downplay the gravity of the crimes charged. In paragraph 354, the defense final trial brief speaks of crimes with limited scope, scale, and number of victims affected. Reason enough to recall the invaluable worth of human life and dignity. Every person locked up in inhumane detention conditions, as imposed on the victims at the Cookus Metal Factory, is one too many. Every single event of mistreatment and torture is a grave crime. And every victim and every single life taken is one too many, permanently destroying the lives of the victims and their families. I spoke about the accused's role. The accused's personal contribution to the crimes was direct, significant, deliberate, and extremely violent. The evidence shows that the accused was personally involved in the arrest, detention, and severe mistreatment of the victims, who vividly remember the accused's actions. They particularly remember him as one of the main actors in the night on or about 20 May 1999, and how he deliberately mistreated them, one after the other. The victims report that the accused beat them as hard as he could using various instruments. The accused hit 4733 with a baseball bat and a rubber baton all over his body, including his head. He beat 1448 with batons on his hands for half an hour, so hard that 1448 almost fainted. And when striking the first blow at trial witness 1, he was smiling. In this night, the victims were beaten until they could not stand anymore. They were beaten until they lost consciousness, and the beatings continued once the victims regained their senses. They were covered in blood, wounded, and in severe pain. None of this was reason enough for the accused to stop. The accused participated in this beating throughout the whole night. He never intervened. He showed no mercy. At no point did he walk out. And he had not enough. After the 20 May 1999 incident, he also participated in the brutal beating of trial witness 1 and the murder victim on or around 3rd June 1999, described by trial witness 1 as the harshest beating during his detention, and ultimately ending with the killing of the murder victim. The accused attempts to escape or diminish his responsibility for the charged crimes by claiming that he was not a leader, commander, or someone who had any authority or control. I refer to paragraph 355 of the defense final trial brief. While he may not have been formally appointed a commander at the Cook's Metal Factory, he was an influential figure, close to people in a position of authority there, with access to the command building and unfettered freedom of movement in and out the premises. Indeed, in 2005, he claimed that it was because of his status that he had been released when arrested in relation to the killing of Halil Gashi in Burel. But the accused was also deeply involved in the physical commission of the crimes. The evidence presented by the SPO establishes beyond reasonable doubt how the accused, through his direct, deliberate, and hands-on participation, and as a member of the joint criminal enterprise, is responsible for the crimes charged in the indictment. Finally, there are no mitigating factors. The circumstances claimed by the defense in their final trial brief in paragraphs 356 to 371 do not meet the standard to be considered mitigating factors. At the time of the event, the accused was a grown man of 36 years, fully aware of the gravity of his actions and the crimes he was committing. None of the presented individual circumstances pre-existing the charged crimes can serve as an excuse for the decisions he took. None of the current circumstances put forward in relation to his family or health situation meet the required exceptional standards requested by the cited jurisprudence. With regard to his allegedly good conduct in the meantime, The SPO refers to the trial panel's findings in its decision on the 15th review of detention in filing 00766, paragraph 26, and the evidence referred to therein. In light of the aforesaid, the SPO requests the panel to impose the following sentences on the accused for the individual crimes charged. For count 1, arbitrary detention, 8 years of imprisonment. For count 2, cruel treatment, 15 years of imprisonment. For count 3, torture, 20 years of imprisonment. And for count 4, murder, 26 years of imprisonment. Pursuant to Rule 163.4 of the rules, the panel imposes a single sentence reflecting the totality of the criminal conduct of the accused. The SPO requests to impose on the accused a single sentence of 28 years of imprisonment. Your Honors, the defense describes the accused as a simple KLA soldier who assisted his people through fighting at the front. I am citing to paragraph 355 of their final trial brief. The evidence in the case at hand, however, proves that he was certainly also someone else. Someone rendering at least 18 individuals to victims of arbitrary detention, cruel treatment, and torture, and murdering one of them. Your Honors, this concludes the SPO's closing statement. Thank you.
Thank you, Madam Prosecutor. Now, it's moment for some further planning for today. Victims' Counsel, I propose to continue tomorrow morning.
Certainly, Honor, yes.
And that would mean that for today we will then adjourn the hearing, and then we meet again tomorrow. Yeah, very well. Before I close this hearing for today, or before I adjourn it for today, I would like to know if from the side of the Specialist Prosecutor's Office there's something you would still want to raise with this panel.
No, thank you, Your Honors.
Okay, very well. Victims' Counsel, is there something we need to discuss?
Only to say, Honour, that we gave our time estimates, obviously, without having seen the details of what was being said by the defence. And we'll have a look at our submissions again overnight in the light of what the SPO said, but we may be a little longer than I suggested, just to give that warning.
Thank you. Thank you. Defence Counsel, is there something you would like to discuss with the panel?
Just one thing, Johanna. It's a question of timing, of course. I hear my learned friend in his explanation, so I would like to know if we have to take the floor during the morning, tomorrow, or at the beginning of the afternoon.
That is something that at this moment the victims Counsel can answer better. Victims Counsel, what would you have in mind?
Certainly in the morning, yes.
Okay. Good. It has been.
Thank you very much.
Very well. Then that has been answered. Very well. Then we adjourn till tomorrow till 9:30, and I thank you all for your participation. Thank you. The hearing is adjourned.
All rise.